Hey guys, welcome to today's video. We got the return of a sovereign citizen I've covered before, along with the no-nonsense Judge Oakley that you all love. I could have uploaded this video yesterday like everyone else, but the audio was so bad that I decided to spend the day cleaning it up, so you clearly understand what's going on and what the sovereign citizen actually says. If you don't mind, drop a like just for the effort. It would mean a lot. Now, let's begin.
Hired appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, requesting the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
But it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed?
Judicial bias.
Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
With all the judicial bias, I just have a statement straight to me telling you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Constitution gets me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means that you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
See, that wasn't so hard, was it? If agreeing with the prosecutor automatically counts as collusion, then by that same logic, every time a judge agrees with you, it would also be collusion. He's already been hit with $2/$100 contempt charges, and we're not even close to being done with this hearing yet.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
when you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that all aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside. That's what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record. You make my case.
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
Well, if this trial is supposed to be in his best interest, then when exactly is the bowl of edible highlighters going to be set in front of him? The judge is right. Pro-SE individuals who have never gone to law school should really reconsider representing themselves, especially if they plan on taking their case to a jury trial. The rules of evidence and judicial procedure can be incredibly tricky and almost never works out in their favor.
And then Your Honor, again, you're trying to spin the sheriff's office.
I'm not spinning.
My objection is based on you stopping me, not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's now once it's on the why is it on the prosecutor to prove those things? There's all sorts of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that?
You're fair.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on the record is that if whatever you would like to do from there, you can, because I'm open until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
We arrested Mr. Crusoe while he was in Huron Township, but before district court has jurisdiction over offenses that occur within the township, both civil and criminal and
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all the
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to,
The judge can't just come in here and say that there's,
It was a little hard to hear him there, but what he said was that a judge can't just come in and declare jurisdiction, when in reality, that's exactly what a judge's job is. This will be covered more later in the video. But for context, the alleged incident took place in the township of Huron, Michigan. By legislative definition, that means this district court has jurisdiction to hear the case.
yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
all she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons that I've stated, there's
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper at the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge. Not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So, that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen,
Mr. Crucell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no?
This is a point where his lack of legal understanding really shines, as he's objecting to just about everything and trying to have every ruling thrown out, including ones that were actually in his favor. To explain, a previous judge had already set aside some default judgments against him, which means those judgments no longer exist. But now he's asking to set aside those set-asides, which would effectively bring those judgments back into play.
Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right, you filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I, all right? The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay,
Prosecutors.
okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent, motion for judicial notice. What does that, judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Like, okay,
For example.
you use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cassell.
That's not how it works. That's not how any of this works.
No, Mr. Cassell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the fourth or fifth time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's another issue of the trial and not emergency stop, motion to stop this.
I already ruled on that.
Certain acknowledge my motions for my next travel. Nothing to do.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right? I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
Even I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. And acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I was having the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
Stating an unlawful jury trial, and I think that waiting statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
Violates my rights to a fair trial. 100%. And you want to keep overlooking. I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses all just because I agree on this. You are aligning yourself with the prosecutor on my right to travel, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shank's mare.
Exactly. When the Constitution was established, there weren't any cars on Earth, let alone in the newly formed United States. While interpretations of the Constitution do affirm a citizen's right to travel, there are absolutely no protections guaranteeing a citizen's right to drive a car.
That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence side that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
Complaint as well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining if it's based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process is working.
Which is not an appeal.
Is an extreme, lawyer when there is bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
Look, I don't know what you think judicial bias is, but I can guarantee there's none here. Or at least you haven't proven any. And honestly, if judicial bias did exist, you wouldn't even be able to continue this very entertaining attempt at eating an entire box of crayons on the record.
You didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crucell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me, my wife had a case before any of this even happened, and talked to us about the traveling. Even told me I was well within my rights. Gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me, he even called me trying to arena. I said, well, it's not an arena. And then he goes towards the motor vehicle. And then he tries to get me to not pursue legal matters. And then he's mad at me. And then the day that I filed for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, and every time I force it to make my case, basically, the court keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How will there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my offense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single bit, and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, that's not. I'm not testifying. That's what I'm saying. It's the amount of traditional bias in this.
Yeah, that's not what either of those statutes say. He cited 2 MCLs, MCL 128.420 and MCL 128.467. These sections simply define the requirements for being a district judge in Michigan and the filing of an oath of office. Nowhere in either of them does it state that if some midwit demands the oath of office be presented to him in court, it must be done or the case gets dismissed. He completely made that up. And this next part is exactly why I love watching Judge Oakley so much.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I don't have a fair trial here with everything that's been taking place. Why I file policy? Why I did.
And I've denied all these things.
Well, of course you can deny it again. Showing them again. Then this.
Once again, Mr. Cruzel, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just not announcing myself because the Secretary of State will make sure I do this. Isn't a big deal. I'm showing.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
So this is where this all stems from. These are the things I've been trying to get noticed. This and talked about this.
What do you want getting noticed that we're not getting noticed?
The fact that this is collusion and judicial bias.
It is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop! I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Again, Your Honor, hasn't established nothing is even put in here, right? And especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way there can be a fair trial here.
That didn't answer my question. I need to know how I'm going to proceed, because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. So it's against that.
Okay.
Everything is on.
Okay. Okay. No, let's on the record as you feel they should be.
I brought sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to just, because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the sport is actually who it's supposed to be.
And that ain't gonna happen.
Yeah, well, anybody showing you were supposed to recuse yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I have to do. Because this person's not going to rule it the way it's supposed to. Not going to stand by your jurisdiction.
Not by your definition, I'm not.
The Secretary of State, Attorney General, and to you, I've never heard anything. I don't even know if you're lawfully allowed to concede it. I am. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Michigan statute or Michigan court rule says I've got to do that.
I have it in there. I thought it was in smoking.
So You're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file with the state, and you provided one X. That is what you have to.
When asked if he had anything else to put on the record, he launched into a long speech claiming the court ignored his motions to dismiss for lack of jurisdiction, to recuse for bias, and for relief from judgment. He argued due process was being violated under the 5th and 14th Amendments, citing affidavits, past Supreme Court cases, and the supposed right to travel. He accused the judge of bias, the Secretary of State of influencing rulings, and the police of misconduct and retaliation against him and his family. He demanded the judge's oath of office, claimed other judges acted without authority, and insisted the township was mislabeling his private vehicle as commercial to strip him of rights. He ended by calling for immediate dismissal, accountability for officials, and declared that without proof he was engaged in commerce, the court had no lawful authority over him.
Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I would put on the record before we get.
How lengthy?
Minutes.
Go ahead. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert that this court has failed to motions by the files of the case. Yeah, slow down so she can make it right.
Thank you.
I respectfully assert that this court has failed to address the critical motions I have filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-101-430, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which being outside the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof of the court violate fundamental constitutional principles. In Murdoch v. Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue interference.
Now that we got that out of the way, would you care to wipe the excess thermometer juice off your mouth?
Additionally, Title 5 USC 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concerns this court has disregarded these principles, given its method of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes on other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the sport, prosecutor, and Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Side, Officer Smith, and Chief Everett Lawless. These violations occurred even after Sergeant Price confirmed that my activities were lawful, yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Norton issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui juris. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent our constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for private public roads. Under the Clearfield Trust Code, version United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The Supremacy Clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of judicial power. I respectfully request that the court issue rulings on the pending motions, including a jurisdictional challenge, and immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sisai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed with the presumption that I am engaged in commerce, it must present evidence to substantiate its claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORV ordinances upon me, and any further actions would be unconstitutional and unlawful.
If his parents couldn't teach him how to be a pro-social contributor to society, I doubt you're going to manage it without sentencing him to at least 30 days in jail.
Mr. Crucell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an phone.
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with this down the road. At least this way, listen. Here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done. Then you can file all your grievances and stuff. Or they find you guilty and you're just filing one more appeal.
Instead of wasting everyone's time.
You've already wasted their time because they're all here. They're all here.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green. And you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
And they had to file with the appeals court that I've been in contact with the appeals court.
Okay, hold on. Let me try to educate you.
So instead of filing a standard discovery request, you went and tried to do your own discovery through a FOIA request. Now you're complaining that the information you got isn't as detailed or substantial as it would have been through proper discovery. And whose fault do you think that is?
You contacting the appellate court, first of all, this should go to the circuit court. All right, you've gone. Okay. So I didn't choose for you to be here, but you're here. Okay, so we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So we're going to go forward today. The only question is, are you going to be in the chair or not?
No, and again, if you wish to prevent it, I'll participate in the bottom one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of her, and all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
told me she wasn't doing this because of the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
Marcus is up and trying to get all this stuff established with the courts and the and I still have evidence that I'm trying to get from the township that they're using lead codes for that, which they did with the policy information that I able and got them to give me the policy because they were trying to use things up.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is where I haven't got it to even get to.
No. Tell me what it is. What
Evidence that was that I requested from FOIA's in the very beginning with my bottle camera.
No. But what is it? You're looking for some records, some ordinances?
Part of the traffic stuff, comments and things that were put in there that.
Hold on. In where?
In the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents that are getting the whole thing.
Yeah, you're being screwed, but not by the court, the judge, or the prosecutors. You're screwing yourself. Maybe take some accountability and realize you've jumped into the deep end of the judicial pool without the slightest idea how to swim.
Hold on, let me hear what she just said. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's bringing things from the south and
You mean like the officer's personal notes? Had notes.
And for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all mean material that can't be discoverable. It can't be shared with people outside those that are have the security clearance to observe or handle the material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversations and the notes that that are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
They withheld this when they should have given to me in the very beginning with my FOIA for everything that's involved in my traffic stop. They didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, how do I want to say this? Personal comments between 2 or more individuals?
No, it's not personal comments. It was stuff that was logged through the traffic stop. Like,
No, stop. but I gotta understand what you mean, logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
Yeah.
Or edited the recording?
As well, that there was no clear reasons why. Every time I try to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything. And then it's in the comment sections of like what was going on.
Hold on, comments on the incident report?
It's not the incident report, it was through the, while the traffic stop was taking place, stuff that was being entered through, like, I can't remember exactly what the paper is I am. Like I said, I'm in the process of getting it all. I'm appealing to the supervisor, and then he vaguely gave, just cited statutes and codes, but he was supposed to tell me how and why I didn't even see them applying to the lead sections, which are failing to do because same thing with.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, it's like, but I have other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and I didn't, part of the design of the whole thing, paper I got from them, they didn't do it in any of the other ones. Only
Hold on. Other one what?
all the, because they're in several reports, several times the cops came out of their house, but we were told, well, this has been going on for all of the years, probably why it's even happened.
Okay.
So I filed every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. But yeah, any of the other stuff, it's all open.
Redacted from,
The whole page is just black.
hold on, redacted from the incident report?
Yeah, from the incident. Yeah,
The paper report that you received?
yeah, exactly.
Okay.
With no justification at all to why any of these things are redacted. I keep trying to, and how they did it with the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer's supposed to operate themselves, right? So they denied several times, stating the same need codes are trying to fix all these redactions now. So I appealed it to the township supervisor, and he released all of my information. And it showed that the policy showed that these officers violated the policy and
Okay, hold on, stop. So he released everything, but not everything you want?
well, then once I realized they were doing this, I went back to getting more. That's how I found out there was more stuff that was never released to me.
Okay.
And then they're doing the same process using these lien codes to not let me see what was put in this paperwork. And that's why I told my American Titans. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way I'm being screwed.
You think your issues are being swept under the rug, but they're not. The judge has ruled on nearly everything you've raised. You only believe they're being ignored because you're not getting your way.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As it is with this stop, he does have the incident report, he does have the body on camera for 4 officers in car, dash cam, what have you. He also personally took a video. I don't have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about, the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or speeding ticket, there are no incident reports. Those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had you veteran.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more now that I've been through the body cams. I had to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. They had nothing to do with lien information that they keep claiming. Same thing with these cat notes she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lien code. But these entire things there's no way the entire pages and these comments and everything are all lien information. There's no way. I've been told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything, the retaliation against me. And I know for a fact what was said these things. That's why I know that being redacted is more than much to say.
Okay. But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my arguments. I've been trying to bring into this court, but everything's just being keep getting.
Because I'm not going to get into all that with a jury.
But that goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not going to let you get into all that with the jury. It's going to be confusing. We're going to go down rabbit holes.
That's why I'm a little prepared, because I need to be able to present my case to the fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
trying to get the jurisdiction established, I'm trying to get the judicial bias stuff taken care of, all of these things that have not, that they've just been it is what it is, just getting swept under the.
Hold on, Judge. Are you sided with the defendant? I'm just waiting for the prosecutor to jump in and accuse you of judicial misconduct and bias against the state. Like you said earlier, if the judicial bias argument works every time you agree with the prosecutor, then it also works against you anytime you agree with the defendant.
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
Without, I give it, yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine, and I guess that's the and I have already started the process, I will be going down it, the more I've been talking.
Okay.
So again,
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
yeah, like I said, I cannot participate in something that I know is not, it is stacked against 100%.
But once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
Oh, it shows that these things have to be established, that there has to be any.
Then
I know that you say you don't have bias, but that, see, I mean.
okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham.
It has to be, and it's all this turned into.
Okay, bring the jury in. I'm tired of talking.
That's the motion will be real quick.
Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Yeah. Did you see that? Hold on. Did you get her motion?
I can't see anything.
You know, you got a copy. You can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday along with our motions.
I have never seen this.
Take a minute to look at it.
I would also like to bring up for the record too that.
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay. All right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything except. I've never seen that before, and
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to
Once again, valid as you determine them,
these advanced to the case.
as you say.
And that's they're the same with the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing all the way to the traffic stop, all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm, again, trying to get all the other matters. I'm not ready for that. So, and I've never even seen it, so I can't even build up a defense to that. To produce.
How was that provided to Mr. Crusoe last week? Okay.
I received his motion, or his $100 motions on Thursday, so it didn't give me much time to respond. I did send it in the mail, I dropped it off at the post office this morning. And I didn't receive his most recent motion.
That was filed Friday. Right.
I sent a letter to someone else, so I know what she was saying. I mean, we've never got first, last name. Never.
All right, so here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point on a point by point basis. Understood?
Yeah.
I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that.
I hate to keep the jury waiting, but at this point, the defendant actually does the smartest thing he can. He steps outside the courtroom to talk with a qualified defense attorney who gives him some solid advice. Now, he's still not officially represented by counsel, but they all agreed that the $300 in contempt fines would go toward the jury for wasting their time. They also decided to move forward with a bench trial in the near future, since that format would allow a more open discussion about his so-called right to travel and how he's confusing it with the privilege of driving a car, something that definitely wouldn't fly in front of jury. That wraps up today's video. It was a long one, but Judge Oakley was incredible and made every minute worth watching. I'll be sure to cover the conclusion once it's posted. If you enjoyed the video, hit the like button. If not, hit dislike. Either way, drop a comment below and don't forget to subscribe with notifications on so you don't miss any of my content.